As far as the President's actions with respect to setting up the BBI Task Force and BBI Steering Committee to further the agenda of promoting national unity were concerned, in my view, these actions cannot be faulted. Indeed, they are roundable acts of statesmanship executed within the ambit of the provisions of Article 131(2)(c) of the Constitution. This article demands nothing less from the President, as it directs the holder of that venerable office to promote and enhance the unity of the nation. However, it is important to clarify that the legal constitutional question before this court does not go to the propriety of the pursuit of the building bridges to unity project. The question before the court is a narrow one, and it relates to whether a constitutional amendment process initiated by the President can be pursued through a popular initiative route prescribed in Article 257 of the Constitution. To answer the question as to who may initiate an amendment process through a popular initiative requires that we understand the purpose that is intended to be served by introduction of the popular initiative as a route for amending the Constitution. This is pursuant to the purposive interpretation decreed by Article 259 of the Constitution. The Constitution-making history that I have highlighted demonstrates that a popular initiative was a tool carved out exclusively as a route for constitutional amendment by citizens. In essence, amending the Constitution through a popular initiative was intended to be a citizen-driven and a citizen-centered process. The citizen-centric nature of a popular initiative is linked to the fact that it is conceived as a means for direct sovereign power to be expressed as contradistinguished with the parliamentary initiative, which lies to the realm of the derived or delegated sovereign power. Under this understanding, the popular initiative is supposed to be triggered from below at the initiative of the citizenry, as opposed to representative institutions. In other words, the popular initiative is intended to give citizens acting outside the institutions of the state a means to activate or trigger the exercise of their sovereign power. This understanding of the centrality of the citizens in activating a constitutional amendment process through a popular initiative is projected in the book that was referred to us by Joe Coron Lois, titled Constitutional Power and the Law. My analysis of Article 257, the history of constitution-making process, and the authority cited in the said book, although persuasive, indicates that a popular initiative is an exercise of direct sovereign power that excludes the representative institutions, that is, the legislature and the presidency, which only exercises power that is derived or delegated sovereign power as distinguished in Article 1, 2, and 3 of the Constitution. In other words, it is a means of direct democracy, and indeed direct democracy can only be exercised by the people, not their representatives, since that would convolute the form of democracy at play. It follows, therefore, that a popular initiative in a constitutional amendment process ought to be seen as an avenue through which citizens engage in the exercise of their sovereignty. As such, state organs, being not bearers of direct sovereignty, have no right to activate the popular initiative. This leads to the conclusion that the popular initiative is a preserve of the citizens, the one popularly known in Kenya as the Wanjiku. It ought to be appreciated that the Constitution provides normative markers for how, when, where, and by whom particular powers are to be exercised. Article 257 delineates who has the power to undertake what duty or obligation as a right to undertake specific measures with respect to the constitutional amendment process. It is in appreciation of this that I need to interrogate the argument that the institution of the presidency has the authority to initiate a popular initiative in light of the overarching right motive of the Constitution, which is concerned with tampering or limiting the powers of the presidency. In its architecture and design, the Constitution strives to provide explicit power to the institution of the presidency and at the same time limit the exercise of that power. This approach of explicit and limited power can be understood in light of the legacy of domination of the constitutional system by imperial presidents in pre-2010 dispensation. As a result, Chapter 9 of the Constitution lays out in great detail the powers and the authority of the president and how such power is to be exercised. Another reason that supports the finding that the president was not envisaged as an initiator of a popular initiative is the role of the president with respect to entrenched matters listed in Article 255(1) of the Constitution, Article 256(5) as read with Article 257(10) of the Constitution, which grants the president a law that can be typified as serving as the guardian of the amendment process. In that, where a constitutional amendment bill is presented for assent, the president has the obligation of reviewing the bill and referring the bill to undergo a referendum process where it involves matters listed in Article 255 of the Constitution. Such a guardianship role over the amendment process ought not to be undertaken by the prayer in the amendment process. I therefore endorse the finding by the two superior courts that the president ought not to be both a prayer and an umpire in the amendment process. The last reason for finding that state institutions and presidents are excluded from using the popular initiative is to be found in Article 255(3)(b) of the Constitution. It shows that the Constitution recognizes a distinction between the people, the state bodies like Parliament. It therefore follows that a state body like the institution of the presidency cannot fall within the rubric of the people, as the very text of the Constitution makes this distinction. This leads me to the inescapable conclusion that state institutions and state organs, such as the presidency, cannot initiate constitutional amendments via the popular initiative route provided for under Article 257 of the Constitution. Nonetheless, this finding does not dispose the issue, as counsel for the president and even the Attorney General sustained an argument that barring the president from initiating or pursuing constitutional amendment process through a popular initiative was a violation of the president's political rights as protected for in Article 38(1) of the Constitution. Given that a process to amend the Constitution is a democratic process which is meant to give effect to self-government, the limitation and promotion of an initiative to change the Constitution is a political choice protected under Article 38(1)(c) of the Constitution. However, there is an additional handle in deciding whether a right is applicable in a given factual situation. This is the concern with the rights range of application as provided in Article 22 of the Constitution, which provides every person shall enjoy the rights and fundamental freedoms in the Bill of Rights to the greatest extent consistent with the nature and the right of the fundamental freedom. What I deduce from this provision is that a court is under an obligation to interrogate whether a person arranging a violation of a right is actually a beneficiary of that right in question. In this context, it is notable that Article 38(1) grants the freedom to make the political choices to every citizen. The citizen qualifier speaks to the range of application of the freedom to make political choices,